Madam President, I teach, I research, and I write about human rights law, and I offer counsel to human rights advocates in areas such as the treatment of asylum seekers and access to the ballot box. I care deeply for the protection of rights, including freedom of expression, and indeed I share many battles with Shami Chakrabarti. But Madam President, it is precisely because I care about the proper protection of rights that I stand in opposition to this motion. Indeed, the motion invites you to endorse the claims that the right to free speech always, that is, in all circumstances, includes the right to offend. Now, if we understand this in the Hofeldian sense, what that means is that a duty holder, that is, the state, has a positive duty, a positive obligation to respect, to protect, and to fulfill the right of a person to engage in offensive speech, even when the sole purpose of that speech is to offend, ladies and gentlemen, and despite whatever harmful consequences that speech may have. And it is indeed against that proposition that I stand. We in this side do not challenge the notion that freedom of expression may be instrumentally significant in promoting the free flows of ideas that are essential for political democracy, and indeed that it often facilitates the protection of other fundamental rights and freedoms. But what we also recognize on this side is that expression often equals actions in terms of its effect, and it may often put other fundamental rights and values at risk. And indeed, that offensive speech causes harm both to those who are against whom it is directed and to society at large. And so what I propose to do in my speech is threefold. I want to first argue that international human rights law is firmly on our side of the debate. Indeed, yes, please. So we'll see. So we'll see what the documents say about offense and about hostility and about the definition of offense. No, thank you. No, thank you. So I want to look at the international human rights law first and say that in all liberal democracies except the United States, which has a specific constitutional prohibition on any regulation of speech, leading you to very bizarre statements like defining certain types of speech as non-speech so that they could regulate them. In all other liberal democracies, including this one, the state does and should regulate and prohibit, indeed, offensive speech. I then want to highlight some of the harms that are caused by offensive speech, and I finally want to distinguish between intentional and incidentally offensive speech. I want to suggest that in siding with the opposition, one can accept that there will be instances in which a speech would be deemed offensive and it would still be protected because it advances other socially valuable purposes. What the proposition needs to show is that all offensive speech, even ones that carry absolutely no other form of social value, is protected, and that's an onus the proposition has not been able to meet. So let's just look at international human rights law. Because freedom of expression is qualified under all international human rights treaties, and that is because its exercise necessarily clashes with other fundamental rights that are sometimes, Madam President, enjoy higher normative status. Those include a prohibition on inhuman and degrading treatment. They include the right to security of the person, and we'll get to how offensive speech may affect that. And indeed, they include the right to life. And if we look at the text of the International Covenant on Civil Political Rights in Article 19, it says that the exercise of the right to freedom of expression carries with it special duties and responsibilities and may therefore be subject to certain restrictions, including for the respect of the rights and reputations of others. And indeed, the same document which this country has signed and ratified says in Article 20 that states must prohibit all forms of advocacy to national, racial, or religious hatred that constitutes incitement to discrimination or hostility, mind you, or hostility, which is very, very close to the term of offense, and that is regardless of circumstances, Madam President. And indeed, the European Convention of Human Rights, ladies and gentlemen, says that an attempt to abuse the use of European Convention rights, including freedom of expression, that is aimed at the destruction of other rights and freedoms, is prohibited. So let's look at the harms of offensive speech first. Now, speech is very often, if not always, intended to have an effect. And offensive speech may indeed have a detrimental effect on the offended person or persons or on society at large. Now, the proposition, I think, agrees with us that speech that incites to violence should be prohibited. That suggests that they recognize that words may indeed, on occasion, have consequences that are harmful. Now let's look at the consequences of offensive speech. Not only does offensive speech often intimate in the longer term the possibility of discrimination or physical harm, but it may in the shorter term cause one or more of the following harms. It may put at risk, as we've heard from Kate and Tim, a sense of status, dignity, and equality of individuals who belong to marginalized groups in society. It may, as a result, create political and social spaces where such individuals and groups are being excluded from either de facto or de jure. And in the end, it may actually end up impoverishing the debate rather than enriching it. Now, I wish to argue that speech whose purpose is to offend, and that is the only purpose of that speech, actually carries no independent social value that is worthy of protection in its own right. Indeed, there are cases, there are cases of offensive speech that are racial slurs, a burning cross, or a sign that curses all people of a certain nationality. These types of speeches either do not advance a political stance at all, or they may advance one that could be expressed in a less offensive way. Now, ladies and gentlemen, I want to draw a normative difference. I want to draw a normative difference between trying to persuade and trying to injure. There are types of speech whose aim is to advance socially legitimate purposes, and they may offend as an incidental, ancillary harms. And what we suggest on this side of the House is that the ends which speech may serve is a relevant consideration in determining its scope and the justifiability of infringement upon it. And I want to end by an analogy to the laws of armed conflict in this particular context. Now, the laws of armed conflict recognize that harming civilians purposely and deliberately is an evil, and so this is entirely prohibited. Whereas there is only a qualified prohibition when you attack a military target and there is incidental harm to civilians. And the reason we distinguish between the two is because we perceive the mere creation of offense as your purpose of action, or the mere killing of civilians in the context of armed conflict as an evil, whereas we recognize that there may be instances where it is unavoidable. So, Madam Speaker, in conclusion, as a society, we accept that freedom of expression is not an absolute right. And we accept that because speech has the potential to affect competing values, in particular the rights and freedoms of others, both in the short and long term. And when other social values, I conclude, are advanced and offense is caused, ladies and gentlemen, then if the sole purpose of that speech is to offend, then on balance, protecting the right to engage in that speech is socially harmful, and I beg to oppose.